Hi everyone, happy Friday. Welcome to the webinar. I'm Christy Bagalow, the Director of Statewide Training for Florida Legal Services. We're going to give everyone a few more minutes to log in, but as we do that, I wanted to go ahead and welcome everyone, let you know this is being recorded, and you'll get a link to the recording in your email tomorrow, along with the materials. I am so excited to welcome Robin and Christina from Florida's Children First. I really appreciate the work they did to get this webinar up and running. This is our most popular webinar ever, so thank you all for your enthusiasm about this topic. And I'll just do a short introduction and then pass it along to Christina. So presenting today, we have Robin Rosenberg, who is the Deputy Director of Florida Children's First. And joining her is Christina Spudeas, and she's the Executive Director of Florida Children's First. Florida's Children First. I knew I would mess that up. So thank you so much for providing this information to everyone statewide, and I'm really glad to see everyone excited about the topic. And I will be available in the chat if you need anything. You can go ahead and type questions into the Q&A box, and we will get to those when there's a break in the presentation. Thank you everyone for joining, and we'll announce the CLE at the end for the attorneys on the call. All right, over to you, Christina.
Thank you. Thank you, Christy, for the introduction. Welcome to everyone. Thank you all for joining us. This is the Child Welfare 2020 Legislative Update, and you know it's offered by Florida's Children First and Florida Legal Services. We thank you all for signing up for this training. We're thrilled to have over 400 attendees. We know that you come from all walks of the child welfare life, and we hope or feel that this will be very helpful training for all of you. Excuse me. Although the flyer for the training tells you there are two presenters, in reality, I'm just the say hello person, and Robin is going to be talking about all the laws. Just for some quick preliminary information, all the laws discussed today came from the 2020 Florida legislative session. The session began January 14th, ended March 12th. Normally, some bills are presented during the session, and usually most are presented at the toward the end of the session or right after session. It takes time during session to get a bill through all the committees, passed on both floors of the House and Senate, and ready to get to the governor. And there are specific timeframes for when the governor must either veto the bill or sign the bill, but there is no time frame for when the bill must be presented to the governor. We had to research that because something happened. Recognize that the last date of the session, March 12th, was about the time that much of Florida began to take serious action due to COVID-19. We were closely monitoring when bills were presented to the governor, but we only saw 6 bills presented before the end of the session, and then we saw nothing. Nothing for weeks. There were all sorts of rumors about the impact that the pandemic might have on the economy and our Florida's budget. So there were rumors about the governor holding off, or not, the Senate or the leaders and the legislator holding off sending bills to the governor because of the economic impact of bills. But finally, we saw a large amount of bills presented right at the end, well, through mid-June, and many were presented to the governor, in mid-June. And many were signed into the law on the last few days of June to take effect July 1st. So we understand it's hard to find these laws because they haven't even been published in many places. And Robin is going to talk to you about that a little bit too. She's done a careful analysis of the laws that affect child welfare, and she's going to tell you about what she found. She's going to focus on what has passed, but we'll tell you also about a little bit about some laws that didn't pass and appropriations also. We hope this will be interesting and informative and helpful to all who joined us today. And I'm turning this over to Robin.
Hi, everybody. It is great to see you all virtually. I'm going to share my PowerPoint. This document, which is actually a PDF, will be available for you along with a summary and a version that's a little more in a like a memo kind of format for you to be able to read and have access to after the presentation. So we're going to start by talking about what passed, and I've kind of categorized it into the big three and the little eight. And major bills, the big three have multiple provisions, and then 8 smaller bills that really affect child welfare. But before we jump into them, I want you to think about why we have bills. We have bills because people perceive there's a problem. It could be a big problem, like a horrific child death that makes the news. It could be a little problem faced by one person who happens to know a good legislator who can make things happen. So the driver behind all the changes in the law are someone's perception of a problem. So I'm going to close the poll. Let's take a quick look. If everybody has a quick look of who all is involved here today, that's exciting, and we have a good variety of folks. And I'm going to close that poll. So let me back up a second. So for all of the bills that we're going to look at, we're going to think about who brought the problem forward. What is this trying to resolve? And I think it helps you understand better what's happening. Why was this bill elected? Was this bill passed? The screen that you're seeing now is a shortcut on how to find the law. And normally I tell people, if you're researching child welfare law, you should just go to the Center for Child Welfare. That's the USF Center for Child Welfare website. You go on their menu screen and you click on policy, and it will give you links to Florida statutes, Florida Administrative Code, Federal Administrative Code, and policies issued by DCF. The reason I think this is the easiest place to search when you're doing, trying to look at what the law says, is that when you pull it up, it will be one page. If you click on Chapter 39, all of Chapter 39 will be on one page. So you can use the search function of your browser to find a term. The second link is to the official online Sunshine, which is the Florida Legislature's publication of the statutes. And that's the official publication. They have statutes by year. So that's a great place to go back if you want to find out what was the law in 2014 or earlier. But when you look in that, it has a search function, but you can't ever get the entire law into one document. So that's why I think child welfare website is the easiest. But for everything that we're talking about today, you're not going to see those yet on the Center for Child Welfare or on the legislative website, because as Christina told you, all of these bills got signed like the day before they came into effect. So the 2020 legislative, official legislative update on the USF, on the Government in the Sunshine Law website isn't up yet. So you will not find the bills that we're talking about inserted into the law yet. So if you want to go and look at the actual text of the documents, I recommend going to the Florida Senate website. The Florida House also has a website that's searchable. I just think the Senate website is a little bit easier to use. So you will see as we look at bills that I've listed the bill number, House bill or Senate bill. That's how you would search on that website to pull up the actual language of the law. So that's a little background. So let's go to first bill, Child Welfare Bill, House Bill 1105. It was Representative Tomko, and the main Senate companion with this bill was Senator Simpson, who is the next president of the Florida Senate. This bill has a lot of things that are solving problems for different people. So it was sort of a catch-all for several other bills that were filed both in the House and Senate, and the key provisions that folks wanted to pass ended up in 1105. So the first item you'll see is requiring judges to take training on secure attachment, placement stability, and the impact of trauma on child development. Okay, so unless you're a judge, kind of who cares what, okay, judges now need to have training. But if you think about what problem is this trying to solve? Clearly there's a perception that judges are making decisions about children's best interest, that are not taking those factors into account. So somebody's got a problem with decisions that are coming from judges and thinks, hey, all of the judges need to know these key concepts for child development. And I think, you know, that stems from the fact that in some places we have judges who have been on the bench and are very expert in child welfare. And in some places we have judges that rotate and may know nothing about child welfare the day before they take the bench. So this is an effort to ensure these key concepts. And they'll be related to some other things you'll see in the law as we go on. The second component in this bill addresses early childhood courts. There was a separate bill that included appropriations and additional staff so that courts in every community could have early childhood courts, and that appropriation didn't happen. Some of the language came out, so we've got the legislature saying, yes, we think these are important. They're just not ready to put the money into it. You'll see, if you look at a bill, especially one that covers a bunch of different areas, the items in the bill are listed in the numeric order of the statute that they're changing. So the first item that we're talking about in 1105 is in Chapter 25 of Florida statutes. And I've mostly kept to the order that they appeared in the bill, although not entirely. The next section is making sure that the hotline and DCF notify the judge if a child who's in an open case has been subjected to another call to the hotline. This is really, again, somebody's thinking the judge needed to know and didn't know what was happening. So probably coming from a case where someone had that experience and had a problem. The next item I have highlighted in yellow, and I've done that throughout this presentation because these are the items that I think most practitioners might come across in their practice and might have an effect. Of course, it depends on who you represent, but in this provision, the problem that's being sought to solve is a problem that DCF was experiencing where an investigation was taken place. The child was determined that they could only remain at home safely if there was a safety plan. The case is then handed off to the community-based care lead agency. And then if DCF wanted to shelter that child, they kind of felt like they were stuck because there's no new allegation about what's going on, but they feel like the kid needs to be sheltered, and they didn't really have a mechanism for that. So this creates a mechanism which says that DCF can file a shelter dependency petition for one of these children who's remained at home under a safety plan if after 90 days, the parent has not, quote, sufficiently increased protective capacities. And if you're a parent's attorney, I would take note of this. There is no definition of what that means in this new provision of law. We asked about that in the process. Like, what does that mean? How does someone determine what is sufficient? So while I think this solves a problem maybe for DCF, I think it might create a bigger problem if there's not some real clarity about what's the criteria for removal at that point or for filing the petition. The next set of provisions were directed to address concerns brought by foster and adoptive parents. They felt that things were taking too long. They had people who were willing to step up to help, to take in children, to adopt children, and the system was taking too long. And of course, you know, there's a great deal of variation by lead agency and maybe by their subcontractors about how long this process takes. But there was an overarching concern that things were taking too long. So this next set of provisions is intended to speed things up. It gives some time frames to when things need to be completed and put some time frames on different people. There's still always the out if additional information is required, but at least this is the endeavor. So if you're working with someone who's trying to get licensed, that's the purpose of this law. If you need to push, then you can use this law to push. Same thing for the adoptive parent process, and it puts time frames. Now this is in Chapter 63, but these are provisions that apply specifically to adoptions from the child welfare system. It actually creates a new provision in Chapter 63, that .093, which is directed at moving along that process. So I've heard from different people about potential adoptive parents trying to get into the system, being delayed and not being able to get enrolled into a course that they're required to take, or being deferred if they're required to take the course until they've identified a prospective match, which is really out of order, right? They need to be approved through a process to even be considered for a match and to have their home study done to determine what would make a good match for that child. So, but this is a response to those adoptive parents saying, we're here, you know, stop saying there's all these children who don't have parents. We are ready to take them. Where are you? So that's what, that's the problem that this is attempting to resolve. I will pause here for a quick second, and Christy, you want to let me know, are there any questions about what we've gone through so far?
Yes, we do have one question that just came in. Are there any provisions in these new bills directly relating to the pandemic and quarantine?
No. So all of the legislation that we're talking about was passed prior to March. So they haven't gone back. The department hasn't taken really any formal positions that we've seen responsive to the quarantine. I will say that they have requested and received a waiver from the federal government regarding the work and school requirements related to extended foster care. So that's not the topic for this today, but we're happy to talk to you about that offline if you want to have follow-up questions about that. None of this relates to the pandemic. So good question. Anything else yet?
That's it for questions right now. Did you want me to launch the poll about where people usually try to find the Florida statutes?
Yeah, no, what? You skip that because
Okay.
I glossed right over there. This is the last little piece on adoptions. It's just to ensure that while adoptive parent training is required for people new to the system, Carrie, go ahead and email in your message, and Christy will read it to me. I see she was raising her hand. This provision is to allow people who have already had the children to not have to retake a training if they've had training within the last 5 years, or they've had the child in their home for more than 6 months and know how to deal with the child's needs. So it's a little exception for that. I don't know, Carrie, was Carrie able to get her question in? I will come back to it later. If you type it up, we'll be sure to answer it. Okay, I am going to launch a poll on this one. So the question is, have you ever been concerned that a placement change was not in a child's best interest? So this is, you know, you've got a kid, whatever role you're in, and there is somebody's made a motion to change the child's placement. Has this ever, so far, a good chunk of you. So this clearly is trying to solve a problem that probably, if I had to guess, that foster parents brought forward to legislators. And we've had a child in our home. The quality parenting law says this child is not going to be moved from our home unless it's dangerous for them to remain, or they're being reunified, or they're going to their permanent home. And yet, many people have experienced placement moves for children that folks are concerned was not a move made in the child's best interest. This provision of law creates 10 new factors for the court to consider to determine whether that change of custody or placement is in the child's best interest. So when you have had that heartburn, you now have a tool to go back and argue at the court, you know, when you're at the change of placement hearing, hey, wait a second, you know, here are the factors that support the remaining or the moving, whatever your position is, right? But now you have some teeth to that. You have some factors that the statute says the court needs to consider in making that best interest determination. And if you remember, I talked about at the beginning, training for judges about stability and trauma. I think these two things are related. Like, hey, judge, kids aren't a potted plant. When you move this little guy, even though he can't tell you he's distressed, he's going to be distressed. And here are the factors you need to consider. So I think those are related, definitely related provisions. The next piece of that is post-disposition change of custody. The criteria for when a child has been returned to the parent, but the case is still open, and whether the child should be removed again from their parent. So previously we talked about children who were still at home post-investigation, but pre-disposition, and whether DCF could file a petition for shelter or dependency. Now we're talking about kids who have been in an open case, sent back home, but the case remained open. Now you have factors to consider when the court is trying to decide, yes, the department is concerned that remaining at home is not safe for the child. Here are the factors that the court needs to consider prior to making the decision about removing from parents. So stop here for a second. Were there any questions or comments that folks had about that?
Yes, we did have several questions come in.
Okay. Let me see if I can take a look at them. The preliminary home study period of 30 days is for all adoptive parents. It's not limited to where a match has been identified. There are changes to licensing and licensure. DCF issued updated its licensing regulations, administrative code provision, and you will see later that provisions relating to how the care children are supposed to receive in out-of-home care they apply to all caregivers. So we will talk on that. The change of custody. So the change of custody issue that I was talking about, the normal post-disposition is moving the child from any place to any other place. And then the second part, the one that's up on the screen now, relates to children who were returned to their parents. And the question is about moving them. Okay. And any legislative history on other relevant factors? I don't think that you'll find, so Maria asked whether there's any legislative history on other relevant factors in the post-disposition change of custody. There are some, excuse me, there's some legislative analysis, but I don't think you'll find that addressed in there. And as this provision, the provision about moving kids, you can argue is for the protection of foster parents, but it applies to any caregiver that has the child. And really, it applies to the child. The point is, in deciding what's in the best interest of the child, the court should consider those factors. So it's not meant to protect one category of caregiver over another category. I think it was prompted by foster parents, but it's meant to protect the children so that the court has the best information from which to determine whether that move is in the best interest of the child. Okay. The question about whether the judge has no voice is actually placed. So as a general proposition, the court doesn't decide one placement or another, but that concept of then previously the state could just pick up and move a child and say it's not a change of placement because they're in foster home A and we put them in foster home B. They're still in a foster home, so you have no say about that. And actually the previous law on quality parenting changed that and said, we don't move children unless it's in their best interest. Not for the convenience of management, it's what's in the child's best interest. And would the statute apply to concerns? I mean, if it's not suitable for the child, and how many providers need to agree that the foster placement's not in the best interest? The system allows any party, and possibly some participants, but definitely any party, to make a motion to modify the placement. So if there's a concern about a foster home, those concerns should be reported to licensing. If those people shouldn't be fostering anyone, the licensing process should be engaged, and that should be examined. If the issue is whether a particular home is best suited for a child or is problematic, motions can be made in that child's case to move the child to a more suitable place. And that's where these factors would come into play. What the criteria that the court would need to consider in deciding whether to change placement. Okay. The same provision, we're still in the big one, the first one of the big ones. And that's the jurisdiction over open cases continues. The court cannot close a case if the child was returned home with a safety plan, even if it's been 6 months or more. The court has to maintain jurisdiction. And then the last little piece of this may be news to some of you, but Florida law required, when we created privatization, required that lead agencies not themselves handle more than 35% of services directly. They had to contract out 65% or more of the services they provide in the child welfare system. This law permits them to go to a higher percentage of services that they provide themselves. Okay. Parenting partnerships, big new section in the law. It creates a new provision in Chapter 409. Many people aren't used to going to Chapter 409 because it's not the child welfare chapter, but it's the one that governs licensing and the agency side of things. So the intent of this section is to improve the partnership relationship between the person who is caring for the child when they're away from their parent and the parent. And the idea is, if kids should go home, if they can go home safely, and the best way to make sure that they get to go home quickly and safely is for the caregiver and the parent to work together. The best way to care for a child who's away from their parent is to work with that parent to know the kid and to have that mutual assurance and agreement and cooperation wherever possible. So many of you are familiar with the contract for licensed foster parents was changed to a partnership agreement several years ago. There's a statewide initiative on quality parenting, and this is kind of codifying the direction that all of those things have been going into. And it is making a formal role for DCF and the CBC to facilitate a relationship between the foster parent and the parent, the child's parent. So I took foster parent licensing class in like 2007. This concept was not raised at all. And the perception was kind of the parents are the bad guys, and maybe you don't want to deal with them, and it might be dangerous. But we know for the most part, that's not true. And certainly this is not to take away anyone's safety or self-protective capacity, but it's to promote good relationships early on because they're in the interest of the child. So that's the key part, that's the key reason for this particular provision. The statute requires all of the parties to work cooperatively together in a respectful partnership. I question how one would go about enforcing that part of the law. And I'm sure there's some parents' attorneys who will bristle at that, you know. But as a general concept, the purpose of all of this is to make the family healthy enough for the kid to be home, and that's a healthy way of doing that. It gives specifics of what they expect out of this partnership and what the roles are, both for the parent and the caregiver working together and for the CBC to support that relationship. For if you represent children, or children's best interest as a guardian ad litem. This next provision is really key. The state is requiring children be placed with caregivers who provide excellent parenting, and CBCs are to support excellent parenting. And this statute lists what's included in excellent parenting. These are things that children should have the right to expect from the people who are taking care of them. And again, this is not limited to licensed caregivers. It is all caregivers. If the state is going to take a kid from the parent and put them with someone else, this is what we expect that caregiver to provide. So I think this could be a big boon for children's lawyers who are trying to advocate for better for their kids. There's more details, and part of what it did was bring over the existing quality parenting law into the new provision of the law. So I'm not going to go through all the details, but I do want to point out in the underline, and I think I've got a poll here. Hold on one second. I can find my poll. So, does anyone know a foster parent who was retaliated against for their advocacy for a child? Anyone? This provision of the law specifies that DCF and the CBC may not retaliate against a caregiver for advocating for a child. One would think that you wouldn't have to prove that or have a law to say that, but now there's a law that specifically says that. So. Okay. I think we're done. I'll let you guys keep voting on that. Okay. The case plan and reports to the court are now supposed to notify the court if the communication between the parent and the caregiver is ineffective, and it negatively impacts the child. And what happens with that? You know, that and $7 will get you a cup of coffee at Starbucks. But the effort is there to keep the court informed and to really continue to pursue and encourage the relationship. Okay, back up one second. I will take a quick look. Any key questions that we want to do here?
Let me see. I just shared the poll results.
Okay.
Just had a comment from someone. I'm in the foster parent licensing system and just wanted to let you know that the idea of the biological parents being the bad guys or dangerous is no longer taught. We train foster parents to work in partnership with biological parents.
Yeah, I agree. I gave my personal experience as a sense of history, and we have some people involved in the system that have that history, but we have a lot more, and I think we've statewide done a great job in the recruiting and training of foster parents to get out of that mode. So I am going to move on because we just hit one of the big three, and we're halfway through our time. So next bill is Jordan's Law. This one made a lot of news because it was a tragic death out of Pinellas County. And you'll see provisions in here that are attempting to solve the problems that people identified when that little boy died. So the first one is training on head trauma for young children, head trauma and brain injury, and several sections of the statute talk about all of these different parties and entities within the child welfare system who have to receive training on head trauma. The next section, and I think again highlighted because it may impact your work, is it creates a process for DCF and law enforcement to talk to each other. So if law enforcement is investigating a case, and even though it's not a child abuse or neglect case, but during the course of their investigation, they have things that give them concern about the child, they are to notify the hotline. Likewise, FDLE is supposed to tell investigating authorities that a person they're investigating is the subject of a child protective investigation. So if you recall in that case, there were some issues about gang activity and I think drugs being sold in the father's home, and those child welfare probably didn't know that he was being investigated for that, and the investigators didn't know that the child living in the home was subject to an open case. So this is intended to make a communication system that works together so that both of those entities communicate with each other. It's, as you may imagine, is a complicated solution. It won't happen overnight, and there's a process set up to put that into effect. I think it's a couple-year process with continual reporting to the state until it's achieved. This is a new provision. I'm not really sure what problem this solves because CVCs can provide intensive reunification services, but apparently that was identified as a concern in that case. It's made it into the law. The next section relates to third-party credentialing agencies. So as you know, CPIs and child welfare caseworkers, and as of last week, guardian ad litem CAMs, and other people in the system are credentialed, have to be credentialed in order to do their job. And so again, in the particular case, there was some issue about whether people who were credentialed met the ethical and professional conduct required by the credentialing agency. So this actually requires the credentialing agency to investigate after the critical incident has been reviewed by the department, and if a complaint is made about one of the parties that what they did was unethical or unprofessional. So it permits credentialing agencies, or actually, it requires credentialing agencies to do an investigation of that person. And as I mentioned, it will be reported on quarterly until implemented. Okay, so real quickly on Jordan's Law, any questions? Christy, are there any?
Yes, we had two questions come in. The first one was, as more rules and expectations are put on foster parents, why have there not been more laws or tools put in place to hold them accountable? It is very difficult to revoke a license, but we keep raising the bar for what we expect.
Yeah, I can't answer that question. I wish I had a good answer for you, but, and then I see retaliation. So it's been described to me. The question is what is retaliation of a foster parent? So I had some foster parents call it the Windex treatment. So they're great. The system is happy with the children in the home. The foster parent's great. They're getting along really well. Then a foster parent, thinks the kid needs something, and they start bugging people for the services for the kid. You need behavioral therapy. He's not getting this. And as the foster parent advocates more for the child's needs, it becomes frustrating to some people in the system. And then, as described as the Windex treatment, I don't know why that keeps popping up. They come in the house for something and they see the bottle of Windex is sitting out on the table, and that's a poison. And then the children are removed because the poison isn't locked up, right? So it's a perception experienced by many foster parents that when they become a squeaky wheel for their kids, they will be retaliated against. Maybe the kids will be removed or other things will happen to them. That's the perception that we're talking about when we talk about retaliation. Okay, so we made it to number 2 of the big 3. The third one is the DCF Accountability Act. And this is the one really made a lot of news. It was a priority for the Department of Children and Families. And, you think about what problems are we trying to solve? So Florida privatized child welfare. We doled out the majority of the day-to-day work to the CVC lead agencies. And then what role is the department left with, right? The state of Florida is ultimately responsible for the welfare of the children. It's delegated that to the Department of Children and Families, and they hold that responsibility even at the same time that a CVC lead agency has that responsibility in a local community. So the role of the department is accountability and oversight. They've purchased these services, contracted with these entities. How do they make sure that children and families are being served the way they're supposed to be served? They do that through accountability. Over the course of time, after we privatized, the resources that were in the Department of Children and Families to do that accountability and oversight were substantially diminished. And so this is an effort in part by the department to say, we want to do this, we need resources to do it. You know, we want to retake our accountability role, and combined with concerns by legislators that there are serious issues in the system that DCF needs to take control over. So this is how we get an accountability bill. The first section of it creates a DCF Office of Quality that applies to everything DCF does. So we're here talking about child welfare, but they also do adult mental health, adult protective services, and they run the access to public benefits. So those are other functions of the agency. All of it is to come under an accountability system. But specifically, DCF has to create a statewide accountability system for child welfare. And these are the things that it is required to do as part of its accountability system. A lot of this work was in place and had other titles and has been trucking along, but it's coming together in a little bit more organized way and an accountable way where the legislature can say, where is this? We've asked you to do it, let's see it. So it didn't limit accountability issues to just to the Department of Children and Families. It looked at all of the players, the key players in the child welfare system. So we know that in several places, the sheriff is the entity that provides the child protective investigation. So it was looking at accountability there. So some of our CPIs work directly for DCF and are accountable under DCF, and others are done by the Sheriff's Department. So the initial version of this bill had all CPIs being measured in the same way. They're all doing the same job. It required them all to follow DCF's practice, you know, I forget what they call it, like their standards of practice that the department creates, and to be measured in the same way. At the end of the day, that's not what happened in this bill. There are some sheriff's offices who have that job of doing CPI pursuant to statute. And those sheriff's offices, in the final version of the bill, do not have to adopt the child welfare practice model, and they don't have to use the same performance metrics as DCF and the other sheriffs who contract with DCF through a grant system. So there's two-part accountability for CPI. The sheriffs named in statute get to kind of do their own thing. The other sheriffs and DCF are held to a different standard. They all have to meet the same basic federal minimum standard, but they're not on the same par with accountability, which I find troubling, because it shouldn't matter where you are in the state for the CPI to be accountable in the same way, but that's how it landed in the statute. I highlighted this because I think there are probably attorneys that represent DCF on the call today. For attorneys that represent DCF, we know most of them work for the department. Some work for the Attorney General's office, and some work for the state attorney's office in the 6th Judicial Circuit. This does require that all attorneys who represent DCF follow the child welfare practice model and be measured in the same way. It has them together doing peer review and monitoring their performance, and they're all on equal footing, unlike the way that it works with the sheriffs. All the attorneys for DCF are held in the same way. It revises the monitoring for the lead agencies. So right now there's a provision that says they can only be monitored by DCF once a year, no more. It takes that away. And it also currently DCF can't monitor, or previously before July, if they were an accreditation agency was doing the same thing, and it's taken that away. It also put a lot more of the measure of accountability for lead agencies. They have to agree to accept technical assistance. It changes the financial penalties that can be imposed so that if they get to the point of a financial penalty, it is not taken from the lead agency and given back to DCF, but it is taken from the administrative expenses of the lead agency and put into direct care for the children to make it a financial penalty that will benefit children, not harm them. Parts of this accountability bill are called the State of Hope Act, and those parts talk about the community alliances and the lead agencies working more with faith-based and community-based partners to provide services to children, to get the goal is to get a better understanding of what's available in the community so people can share and get the services to the children. The part of the State of Hope Act is support for child protective investigators, and it's putting in programs to mitigate and prevent secondary stress and burnout. The idea being the more stable workforce, the better off children and families are, and here are some things that can promote stability of workforce. Along those lines is DCF and the Florida School of Social Work, FSU School of Social Work, doing a curriculum to improve professional development and to create a career ladder so that, again, incentivizes people to stick with this job and to grow into the job. So I am going to not take questions now because of our time. I will stay on past 1 o'clock to answer your questions, but for folks who can't stay on, I am going to go through and make sure we get at least to the Little 8 bills in the next 14 minutes. Okay. So adoptions benefits, this expands the one-time adoption benefit to include state workers who are called OPS. If you are that, you know what that is. Also to veterans. And adoption records, solving a problem of adoptees and parents not being able to get information without a court order. This new bill law allows each of the parties to themselves determine that they're willing to let other parties obtain the records with their information on it. And so if the other parties do, the person requesting the document can get all of the information, or if they don't, the people who don't agree can have their information redacted, but the people who do agree's information will be shown. Service Member Relief Act is really bringing over federal law into Florida law to make sure that we're not disadvantaging members of the military because of their service in the child welfare process. Technically, it is the existing law in the United States. The proponents of this, which were the regional council, and yay for them, this I think was their first bill of their own that they got passed, and that's awesome, is to make sure that by putting it in Florida statutes that people know that it's there and don't ignore the rights of the service members. This next section might be helpful to a lot of people. So Florida has a good temporary custody law, 751. These allow families to make their own arrangements, maybe having nothing to do with the child welfare system, but sometimes as a diversion to the child welfare system, when everybody knows things are falling apart and they're going to change their own family arrangement. Under the previous law, those temporary custody arrangements can only be made with people who are relatives, I think within 5 degrees. And so this allows the parents to select their fictive kin. You know, Aunt Alice, who's my best friend since I was 5, but bears no legal relationship to me. So fictive kin is defined in Florida statutes in Chapter 39. It opens up the world to make good legal arrangements, custodial arrangements, thoughtful ones, with people who are not technically legally related to the child. So major, major improvement. And it also puts in some best interest considerations before children are returned home, and to put in to think about transition. So the concern here was temporary custody and concurrent custody, which is part of that law, can be, it's based usually on agreement between the parent and the caregiver, and is intended to be easily undone so that the parent can regain custody of their child. And yet in doing that, there were many cases where children who were moved without the transition that Chapter 39 requires, to be thoughtful for the child, respectful of the child, and their property and their psychological needs and connections to that person. So this allows upfront for those transition considerations to be put into the petition and the order, and also gives permission to add other things that would be in the child's best interest that come up within the context of the family, that they're planning ahead what else needs to be considered at the time the custody changes back to the parent. So it's intended to be a boon for building those relationships, but protecting the child more as that custody comes apart. Next item is school-based Medicaid. So kind of geeky thing, but Florida was not permitted to, the schools in Florida were not permitted to bill for Medicaid for children unless they had IEPs. So they could provide the services, but they couldn't bill for them. This takes away that law. Should have been doing it since 2014. We've lost out on all that money, but it was a great thing to pass. The kid care removed the cap. There was a lifetime cap on covered expenses of $1 million. So hopefully that won't affect anybody you know, but if you do, it's a really amazing thing. That law was effective when it was signed, and that was signed back in April. So that was pretty exciting. This next major bill, I think, will affect a lot of folks, and I'm going to put up my last poll. This is an attempt to address the serious mental health needs of children and adolescents, not just those in the foster care system, but in the community and in juvenile justice, and who bounce around and go back and forth between those systems. And so the goal is to create a coordinated system of care and to minimize the use of hospitalization and try to maximize other community efforts that can address the needs of the children and the people around them in a more effective and efficient way. So it's intended to integrate all of the different child serving systems and creates these MRTs, mobile response teams, that are now supposed to be part of the system of care. So the intent is to engage the mobile response team before shipping it, calling the police and having a child Baker acted. Like, how do we get to right services? It has requirements for the managing entity, which, if you're not familiar with that term, so we know that DCF has contracted out child welfare to lead agencies. Likewise, DCF contracted out mental health services to very large entities called managing entities. So all of the mental health and substance abuse money for a particular area goes to that entity, who in turn doles it out to the sub providers. So they have responsibility for building this system of care and to create these mobile response teams who will provide immediate on-site behavioral health crisis services. Who is eligible for that criteria, that service is listed here on the slide. And again, you'll get all the materials for your use. So the mobile response team is supposed to respond within an hour if the case is a prioritized case, be there in person, and directly address the needs of the child at that time, and then screen and refer them to whatever ongoing community services would be helpful to them. This, as a comprehensive law, it requires foster parents to be trained on the MRTs, and it requires the CBCs to make sure that all caregivers have the MRT contact information. And it goes into the school statutes and tells the school principal, before you or your designee calls the law enforcement, you have to verify that you've tried de-escalating and you've used an outreach to mobile response team. Of course, there's an exception unless you reasonably believe that a delay will increase the likelihood of harm to the student or others. But the push there is, let's stop Baker acting kids from school. Let's get them to the place that they need to be. So it's a good chunk of where you guys have seen kids Baker acted from. It also has a function of review and analysis to determine how things are working, to make recommendations for improvements. And I highlighted this for the bottom section. So it requires ACA to continually test the networks to make sure their providers are accepting patients and that patients can get there. So I didn't put up a poll, but I know I've talked to many of you before about your kids needing mental health services and the providers are not available or they're not taking new patients. And that issue was recognized in the statute, and ACA is supposed to continually check on that to find out about availability. So when you're advocating for kids or systemically in your area and you see that as a problem, dump it back to ACA, because it is their job to make sure that providers are available, and specifically with regard to this. Last of the big 8 is not a child welfare law, but it's the removal of the statute of limitations on prosecution for sexual battery when the victim was younger than 18 for offenses committed after July 1st of this year. So going forward, there will be no statute of limitations. I have listed on here what failed. There were efforts to expand the definition of harm in Chapter 39, increase of child care subsidies for foster parents. The early child court bill with the appropriations didn't pass, but other provisions did. Privileged communication would have added the clergy privilege to the list of privileges that don't apply in child welfare cases. Florida Youth Shine promoted a Bill of Rights to collect up their existing rights into one place so they could be advised of their rights, and would create the ombudsperson position in statute. So DCF has one, but there's not a statutory base for it. It's just a program of the department. Items on restitution for juvenile offenders and diversion expunction did not make it through. Sadly, there were great juvenile justice provisions. Temporary care of a child's been brought forward a few times. It would have codified sort of the shadow foster care of non-licensed care for volunteer respite families. DCF's bill on one of the bills they promoted, which had provisions on how to, again, trying to solve problems, deal with an issue where both parents are deceased. It also had provisions relating to adoption and paternity and change of placement that didn't make it through. Support for incapacitated adult children would have pumped up the requirement for parents to continue supporting their children. Not a child welfare bill, but an important bill for kids with disabilities. And the bill linking child-on-child sexual abuse and animal abuse likewise didn't pass. At the end of these slides, when you see them tomorrow, I have provided you 3 slides that DCF provided to the Child Welfare Task Force at the end of June that show where their appropriations were, what appropriations they got in the key categories. So, you know, follow the money, that's where the priorities are. So that will be in your list of materials. So I'm gonna stop here 3 minutes early and take a look at the questions and see if I can answer some before everybody has to go. The statute for the State of Hope Act. Okay, so you're gonna get all of these materials. So you're gonna get this PowerPoint, but you're also going to get a document that looks like this, the 2020 Legislative Update, which has each of those laws and statutes. And that will be in your materials. And I'll go back and pull it right into the answer for you. Laura's volunteered her services. She's at Bay Area. She is like the expert on temporary custody and making family provisions. So take advantage of her. Do fictive parents earn benefits? So the under 751, so it's a temporary custody situation. If they picked a fictive relative to be the caregiver, that still is under 751. So it would, it does not come with any benefits, and that person would not be eligible for relative caregiver benefits under Florida law. They may or may not be eligible for child welfare benefits for the child. And not child welfare, but welfare benefits, temporary cash assistance, possibly. And I would rely on one of my legal aid colleagues who's a benefits expert to answer that. But nothing the 751 law does not come with any benefits. And Teresa, I don't know if that's the same when you say provided funding for services. I'm not sure which services you were talking about. And somebody raised their hand. I don't know how to call on you. You're welcome to type in more questions. So Chrissy, do you want to say something? I'm going to stay on and I will answer questions. But do you want to say?
A few questions come in through the chat, but first I just wanted to thank Robin so much for breaking down all that information. That was a lot of information to put together for us, so I really appreciate that in the middle of a pandemic on top of everything else. And I did want to give everyone the CLE information. I'll also type it into the chat box and it's on the last slide there. But in case you're listening by phone, the CLE number is 2004-532, N as in Nancy. Again, that's 2004-532, N as in Nancy. And everyone on here will be getting a link to the recording and all the materials, including the CLE. Let me go back up in the chat box to find those questions. Someone asked, what is the DCF model of representation by its attorneys?
So if I use that term, I was mistaken. They don't have a model of representation. They have, I don't know what their internal standards are, but whatever they'll be measuring by way of accountability will apply across the board. I know that they have an internal process for reviewing and managing their attorneys. I don't know the details of that. But it's not a model of representation the way when we talk about how attorneys and guardians ad litem in Florida represent kids. It's not that kind of model of representation. I will direct folks to, there is a ABA model standards of practice for attorneys who represent agencies. Florida doesn't have a Florida specific version that's been published, but if you want a sense of on the national level what the expectations are for those lawyers, that would be the place to go look for that.
Okay, thank you. And another question about billing Medicaid. For billing Medicaid outside of an IEP, does it still require the parent to consent to bill to Medicaid?
I don't know.
Okay. And who is authorized to request a mobile response team?
Anybody who is in crisis with a kid can request it. So if your neighbor's kid is over at your house and your neighbor's whatever not there and you think it meets criteria, so there's not, the idea is for it to be an immediate crisis response. So if you're there with the kid, you can request it. Now, if you're working for a school system and you're back in school, the school might make an internal protocol, but the law does not limit who can request that assistance.
Okay, thank you. And lots of compliments coming in for a great presentation. Someone asked about the statute, but I think you said that that's all in the materials. So everyone will get the slides and the recording so you can refer back, because I know this was a lot of information in an hour.
Yeah,
lots to digest in an hour. And we've kept you all from your lunches too. Let me see. Someone asked, have they provided funding for the services? I think that was in reference to the Baker Act alternatives.
I believe there was funding put in for the children's mental health bill, and when you get the materials, take a look at the list from the appropriations. So I can't swear to it, but I do believe that it was included. And it was a pretty massive endeavor that was made.
Okay. And someone asked if you are a FCB training provider. I don't know what that is, pardon my ignorance.
Is that the Florida Certification Board?
Probably, that sounds good.
Probably. we are not a formal FCB provider. Nobody's ever asked us that before. So I don't know what is required to do that, but that's something we can take a look at if that would help people, use these materials to keep up their certifications.
Okay, and anyone who has questions, I'm going to put my email in the chat box, and I can send you the attorney CLE certificate and see if that helps, or fill out anything you need me to fill out for your agencies. pardon my ignorance about all these other programs and certifications.
Yeah. So, and if you also would want to add into chat, if there are other trainings that you think we could provide, if there are any of these topics that people want to get into in more depth, or we were talking about this morning, the online resources that are available, both like the USF Center for Child Welfare has some amazing resources. We also operate the Florida Dependency Law Center, which is available for attorneys, and hopefully a lot of you are already users on. But so there are a lot of, we may do another webinar just on what all the different resources are, and we will try to get tech credit for that because I know people need tech credit. So we're thinking about how we can serve you best in this weird time where we can't come to your city. So we appreciate everybody who attended, and could join us virtually.
Yes, thank you all for your attention. And there will be a short survey at the end, and it does have a comment section. So if you want to suggest future trainings or volunteer to do one, I'm on a kick right now about technology, just trying to showcase what different agencies are doing to keep in touch with the public and community partners, partner agencies during this crazy time, because I know we all thought we would be back to work as usual right now, but we are not. So I would love to see everyone's creative ways of dealing with that. Thank you again so much, Robin, for all that information.
Sure. Thanks, everyone. I'm sorry if my cursor was in the way.
All right, it was wonderful. Thank you all so much. And you can contact me if you have any questions. You should get an email from Zoom tomorrow with the recording and all the materials. And I hope everyone has a wonderful weekend.
Bye-bye.
Everybody.